2 years. And in that case, you have to provide evidence that why you want to seek that leave. Although there are exceptions under Section 30, Section 30, subsection 3. And those exceptions are where you have exceptional hardship. And there are different reasons, and there are authorities on this, or where there is exceptional hardship to the petitioner or depravity on the part of the respondents. If we read authorities like Majekodunmi against Majekodunmi, Okonla-1 they show different areas where you can bring that application and the court will allow you to go on with your petition. If they have children in the marriage, the court will consider that. Most times, the court can refuse to grant that application. And if the court believes that there is a possibility of reconciliation, and that is why now there are options for mediation in family matters. So if the court finds, oh, you are young, these are turbulence that come with early marriages, go and discuss. The parties can be asked to discuss, and then it will move on. Now, if we have gotten those backgrounds, there is a sole ground for dissolution of marriage. I want to say this again, a sole ground. And that ground under Section 15(1) is that the marriage has broken down irretrievably. So you find that in your petition, the first part, you state there that the marriage has broken down irretrievably. In the petition, there is a provision for the facts to support that sole ground. But unfortunately, when you see some petitions by our colleagues, they will start, those facts is what they will put as a ground. There's only one ground, and that the marriage has broken down irretrievably. And there are 8 different facts that can enable the court to find that the marriage has broken down irretrievably. I will not go too much into them. A few of them I will discuss, maybe because of they are common around us. So the point is that one sole ground, but there are 8 different facts that can assist counsel to prove those sole grounds. Now, willful and persistent refusal to consummate, that one is marital intercourse after the marriage, not before. But I want to talk about adultery, which is a fact that most of us as practitioners use. Adultery per se does not mean that a marriage has broken down irretrievably. The petitioner must, in addition to that adultery, prove that it has become intolerable to live with the respondents. So it is adultery plus intolerability. So you can't just say, oh, he committed adultery. The commission of that adultery, has it made you intolerable? If a petitioner alleges adultery and within a period of 3 years already have 2 children for the respondents, it becomes difficult for the court to say the respondent is, the petitioner is finding it intolerable. So the point that is being made is that if you are going to use adultery as a fact to support your sole ground, you must show these 2. I've seen petitions where the party will just allege adultery, but will not allege that it is intolerable on the part of the petitioner. That fact will fail. Then another thing about adultery is that the party that the adultery was committed with must be joined as a party. So if as a co-respondent or a party cited to the petition, so you will now have 3. That's 2 respondents, and then you have the petitioner. If you don't join the co-respondent, that's the person that adultery was committed with, you can't succeed on that ground. In some cases, the court will find that definitely you can't prove that adultery. Don't say, oh, I've mentioned that party in the petition. Some will say, I mentioned the person and said, oh, he committed adultery with A, B, C, and D. Did you join that party as a co-respondent so that you will be able to reply? And that is the case of Ebe and Ebe. And I'm sure most of us have read that. Now, Erahon and Erahon is a very funny case. Funny in the sense that the burden of proving adultery, courts have seemed to take it higher in the absence of admission. You can have admission by discretion statement. I will talk about that shortly. In Erahon and Erahon, there were photographs showing compromising situations, and the court found that that was not sufficient. So you wonder what would be sufficient. So what is the point that is being made? If you are using adultery as a fact, be prepared. Your evidence must be very weighty. Now, behavior the respondent cannot be expected to live with, there are several behaviors. And then you look at them in section 16. Now, disaction for at least 1 year before the petition. Now, there must be a de facto separation and then intention to withdraw. What that means is that if, for instance, parties agree that, oh, you go abroad, go and make money, bring the money, that is not disaction for purpose of the law. There's a de facto separation, but the animus, the surrender is not there. So if you are relying on desertion, you must show. Sometimes the parties may not desert from the beginning, but they may desert later. When you say, okay, come back, let us come and drink the gari, where I don't want you to stay again. In that case, and the party says, no, I'm not coming. Desertion can start. There's a matter I'm involved in that the respondent moved. He moved houses because where they were staying was too expensive. And he said, please come. This is a cheaper place. Let's move here. And the petitioner refused. So it's for the court to decide who deserted. Is it a constructive desertion or there's an actual desertion? So these are areas that the court will look into. And as legal practitioners, we want to plead relevant facts. For instance, a lack of just cause to withdraw. Because you can say, I didn't desert, but your action could have made the other party to go. You will be in desertion, then without consent. So it could be willful or it could be constructive. So these are various forms of desertion. Then I quickly take a few of them, living apart for at least 2 years. The respondent, if he says he doesn't object, there are various ways of showing you don't object. Maybe by making the petition undefended, and you have lived apart for 2 years, then the court will be in a position to grant your petition. Now, the living apart for 3 years is what is called no-fault rule. And I don't know how many of us have used this. Because if parties have lived apart for so long, why would you want to be going into who was at fault, who was not at fault? They have lived apart for say 10 years. The marriage is more or less a shell, and that is what is called the no-fault rule. This has been developed more now in the UK under the new act. Because of the case of Owen and Owen, I've written something like this, an article on this part, to show that no-fault rule, some courts, when it is no-fault rule, why would a judge go into the nitty-gritty, you are at fault? But we have seen judgments where, although it's a no-fault, the parties have lived apart for even 10 years, the court is still going into who was at fault or who was not at fault. So I think those are, I mentioned there are 8 of them. I just took a few of them because of our time. Presumption of death. This is a particularly tricky one because you must, if the person has been absent for, say, 7 years, you must be able to prove that, that yes, I'm in a position to remarry now because I've not seen him. So these are areas, but you must plead those facts. And then you'll be able, if you go to section 164 of the Evidence Act, you see similar provision, what you must plead. So what is the point that is being emphasized, colleagues? You know, petition for dissolution of marriage deals with status of the parties. So a sole ground, it has broken down irretrievably. But which fact do you want to use? You can use different, you can take out of these 8. It doesn't have to be one. The old rule of cruelty, if you have read the case of Adaramaja and Adaramaja, is no longer in force in Nigeria, but you can bring it under the number 3 here, that the behavior of the petitioner is such that the behavior of the respondent is such that the petitioner cannot be expected to live with that respondent. So in that case, you can bring in cruelty, but you can, sometimes I see cruelty, it actually comes under this behavior that cannot be expected to live. Nagging, always beating, and all of that. You can't be expected to live with the respondent in that case. So these are some of the areas that I've discussed. Because of our time, we won't go too much into them, but I'm sure that we've gotten the gist. If there are questions, we'll take them later. Now, let's talk about pleadings in matrimonial causes. Now, why are we looking at this? Let me, I hope I'm not covering the slide. You have the petition starts, you see the diagram. If you are seeing my slide, you have the answer. Then you have you can have an answer and a cross petition. So that means that the respondent is also bringing a petition for dissolution of that marriage. There's what we call answer under protest. So what that means is that the party, the respondent, may decide to say, no, there's a legal issue why this petition should not go on. We will file an answer under protest, and that point of law will be set down, and the court will decide it. If the court agrees, then the petition is struck out. If not, you'll be asked to file the answer within time. And then you have the reply or the answer to the cross petition. There's one area that I just want to draw our attention to. There's what we call reply under protest. You know, I mentioned that in a case where you have a co-respondent or a party cited, he might file a reply under protest. In that case, because it is the petitioner, he might also file an answer under protest or a reply under protest, depending on the process that is before the courts. So that is, when you see anything under protest, is that they are raising a legal issue why the matter should not go on. Then you have rejoinder, you have further rejoinder. There are all further pleadings that you can have in a matrimonial cause. So when we talk about pleadings, we are not only saying petition or the answer. So you see the various gamuts, as long as you can file within the time that is stated, some within 14 days. So those are what we have. Now, this slide talks about the various, what you have in a petition. I think we can all relate to that. The heading, the parties, the marriage, the birth of petitioner and respondent, the domicile, just like what I've mentioned, the cohabitation, the children, the previous proceedings. Then you have facts to support your ground. So and then condonation, connivance, and collusion. This is particularly important. You know, you can't connive to dissolve a marriage. You can't collude because it would be against public policy. Marriage is a sacred institution. You can't collude and say, oh, come, let's go and divorce. Let's agree to divorce. That is collusion. You can't connive. So you state it there. And if there are children of the marriage, arrangement for the children, then the maintenance and settlement of property, the order you are seeking, and you date and sign. You can always find this precedents in various, in the MCA, you find the precedent, and you can find them most of precedent books. Now, I'm going to run quickly through the documents that you should to support a petition. That's what we call a notice of petition. It's just to tell the respondent, these are the things you are going to do. I'll take a few of them, why they are important. Now, your petition, you should have a marriage certificate, a photocopy of a marriage certificate. You attach it to your petition. Now, why is this important? You know, we talked about jurisdiction. The registrar who is assessing will ask, where is the marriage certificate? If you don't have marriage certificate, you have it's a photocopy. If you don't have, you go and get a CTC, attach a photocopy of it. It is when the trial begins that you tender the original. There's the interesting case of Ayeguna and Ayeguna. I don't know whether it is something that can still happen. If you're able to show that for a long period of time, you have cohabited, and there is evidence of a monogamous marriage, you may be able to show a statutory marriage. But it becomes particularly challenging now. There are ways. If you went to the registry, there are duplicate copies in the registry where the marriage was celebrated. You get a CTC of it. Even if it's a licensed place of worship, which we discussed in the last webinar, you can always get a certified true copy. Let me tell you where this can be a problem. And that is, I don't know whether it's peculiar to Nigeria. When you attend a wedding, the moment the registrar of marriage is pronounced, I pronounce you husband and wife. The wife, the family of the wife quickly tells her, collect the marriage certificate, collect the marriage certificate. That's your, and you wonder whether that can preserve the marriage or not. A certificate does not preserve a marriage. And parties are even free to obtain a CTC anyway. So most times when your client comes, they'll tell you, the marriage certificate is with my wife. So as practitioners, what we do, get a CTC of it. And if you are not able to, you can subpoena the registrar or take process to get it to courts. So these are areas that may be challenging to us, and then we need to take care of it. Now, acknowledgement of service is important where service is going to be by post. There's what we call a Form 11. So you attach it to your petition. What that means is that when the respondent receives the petition, he will sign that acknowledgement and return it under a registered post. So that is Form 11. Now, I want you to go and read this a Naluke and a Naluke, because service goes to jurisdiction. The petitioner was not able to show that Form 11 was attached to the petition. What the petitioner did was to show that, yes, you know, the belief has sworn to an affidavit of service. And the lower court accepted, but the Court of Appeal said, no, Form 11 is mandatory. You are expected to sign and return because it's by post. So all these are things that we need to know as practitioners. Now, I want to talk briefly about the verifying affidavit. The verifying affidavit is mandatory and is to verify the truthfulness of what you have in the petition. Now, I've written on this verifying affidavit, whether it's of substance or of form. Now, what the law, Order 5, Rule 10 of the MCR says is that it must be part of that petition. So what that means is that your verifying affidavit cannot be on a separate sheet. So if you have your petition, before you conclude, you have a heading, verifying affidavits. The same process, and then you sign. Now, several cases where there was default in verifying affidavits and the court have struck out the petition. Now, there is a move. If you read the case of Odushote and Odushote, there's a move away from strict technicality now. And it says, okay, if you have it somewhere and there's intention to verify, then we can take it that the petition has been verified. So please prepare a valid verifying affidavit. Some courts still go back to Anyansho and Anyanso, Unegbu and Enegbu, and strike out petitions because they were not properly verified. Now, this is another area. Order 7, Rule 11, all petitions must be, all pleadings must be verified. Did you notice that we refer to various pleadings from the petition, the answer and cross petition, the reply, the protest? If there are facts, you must verify them. And that's why this Omodiate and Omodiate had criticized it, because the court was of the opinion that it's only the petition that needs to be verified. But Order 7, Rule 11 shows that you must verify all pleadings. And we have mentioned the gamut of pleadings. My contention in relation to this Omodiate is that it was arrived at par incuriam. The court did not consider Order 7, Rule 11. Even counsel did not bring that to the attention of the courts. So what is the point that is being made? You need to verify all pleadings by verifying affidavit. Not too long, not too many paragraphs, just to say you verify, you know about those facts, and you vouch for them. Now, another thing is the certificate relating to reconciliation. As counsel, we have a duty to try to reconcile parties. So even if you are briefed, you can still hold a meeting to reconcile them. And then you can sign this certificate relating to reconciliation to show that, yes, you have taken steps to reconcile the parties. So that is also a document that you must attach to your petition. Now, discretion statement is not what you attach ordinarily. And the reason why I have brought this discretion statement is that if a client comes to you and say, I want dissolution of this marriage, I'm in a relationship with another person. Of course, if the client doesn't tell you, they have committed adultery because there is subsistence of that marriage. But that your client still says, I want that the court to exercise discretion in my favor to dissolve this marriage, irrespective of the fact that I've committed adultery. That is what is called a discretion statement. And that discretion statement must be signed. And you state the circumstance, the party who made it will sign it. You put it in an envelope. So you headed discretion statements with the suit number and the parties. And the legal practitioner can also give a certificate signed by the party itself. And then you say discretion statement filed on so and so. Now, when the court is confronted with such a situation, you find that the moment there is an envelope showing the discretion statement, the court is already aware that the party is saying, despite my adulterous relationship, I still want the court to exercise that discretion. So, and you must do that before the filing of the petition. It could be an answer. For instance, if the respondent files a cross petition, it can file a discretion statement. So even after the filing of the petition, you can still do a discretion statement but before the trial. So you are asking the court to grant that discretion and dissolve the marriage. There's what we call the compulsory conference. Okay, let me run through this. Now, if you are a counsel that you have the custody of children or the maintenance is an issue, or the settlement of property, you can call the other party for well, the compulsory conference must be had before the matter is set down for trial. So you meet, you can say, okay, this is our agreement. If you don't agree, then you come back to court. In a recent matter that I was involved in, I told the court, we'll need to set this matter down for trial because the parties could not agree in a conference. They were abusing themselves, allegations here and there. So what that means is that the compulsory conference failed. So if the court can still set down, but with leave of court, and the court granted leave, and all the forms were filled. So this, the point that's made here is that compulsory conference is what we should do as practitioners when a matter comes before us. Because if you arrive at a good position, that will assist. Sometimes parties may even agree to divorce, not agree in the sense of collusion. A party files a petition, another cross petition for the same dissolution. The issue may just be settlement of property, or the maintenance, or even the custody of the children, or the welfare of the children. So in that case, you find that a compulsory conference will be very relevant. So, but don't let the failure of a compulsory conference to stop you from going ahead to set aside. Go back to court and seek the leave of court. Compulsory conference has failed because some may use it to delay the matter setting down for trial. Now, service of petition, I think we are, as counsel, we are already used to this. Personal service or substitute service. I've discussed Form 11 when there's service by post. Substitute service, we also know ex parte application, last known address, and all of that. So the MCR provides for personal service or service by post. So you can show that. But I've shown by this case that this Enaluke case that your Form 11, not the affidavit of service by a bailiff, the Form 11, if it is by post, you must show it duly signed. That is the proof. Now, I run through when the trial process. A defended petition, you need to set it down for hearing. You fill a Form 32. If it's undefended, we know what undefended petition. That means the other side did not file anything. A defended, there are joint issues. You file a Form 32, and then there's a registrar certificate that the matter is right for hearing, and the hearing. Please, hearing must be in public. When we say in public, open courts, where parties are accessible. Menekaya was a case where they went into chambers to hold a proceeding for dissolution of marriage. Of course, antecedents of the parties, they didn't want the press to know, but the Supreme Court set it aside. It was a nullity. So whatever situation you have, don't let your hearing be in chambers. It will be a wrong one. Now, for a defended petition, as I run through this now, with a few minutes I have more, oral evidence must be taken, and it could be documentary. And then another thing, presently some courts, there's a witness statement on oath. Some courts can direct that you file a witness statement on oath. It's allowed. And then from the case of Olaniyan and Olaniyan, the petitioner may not give evidence, but if we can show by other means that, yes, the marriage has broken down irretrievably, the court will grant the application, the petition. Now, Section 82(1) is very important of the MCA. you must show to the reasonable satisfaction of the court. Don't believe that because you have filed a petition, the marriage must be dissolved. It doesn't work like that. Marriage deals with status, and courts cannot cannot disrupt that status of marriage. Marriage one goes beyond any of us. So the court must see that, yes, this marriage has broken down irretrievably. Otherwise, the court will not allow it. Now, there's a problem area, and that is where you have undefended petition. I know that most of us, especially when you have clients that are abroad, the parties have lived apart, you say, oh, it's undefended. We take it for granted. Unfortunately, some of our courts are also, they also, what do I say? I won't say complicit. They also give a sort of leeway to counsel to believe because your petition is undefended, it's a matter of course. Please, there is nothing like consent judgments in matrimonial causes. I've written about this in an article, Evaluating Consent Judgments in Nigeria. Some courts, they will say, go and file terms of settlement. And they say, we agree to divorce. That is wrong. Parties, section 44.3 says, the court shall not grant a decree of dissolution of marriage without receiving evidence by the petitioner in support of the petition. Evidence must be taken. So the court cannot even decide on affidavit evidence alone. A matrimonial cause proceedings, they are sui generis. Then in the class of it's not like other civil proceedings say, oh, in default of appearance, in default of enter judgment, because it deals with status and for public interest. So for undefended petition, you need evidence, even if just to recount what is there. Courts can refuse to grant a petition even if it is undefended, because you have not shown that there's the marriage has broken down irretrievably. So I think that's why I said I should make this point so that we know that please don't take undefended petition for granted. There are authorities for that. Oral evidence, section 44.3 and section 82 of the MCA, they are very important. All right, so I think I've talked about this. Now let's talk about the decree nisa and decree absolute as we run through where we are. I think I still have a few minutes. Now, okay, I have some time, up to 4:20. Now, the decree nisa, now we have a situation where we have gone through the gamut of the trial. And I've told you, you can't, even if it's undefended, please lead evidence. Even if the court says, is it not undefended? Still call your witness, that is it may be the petitioner, and give this evidence. You tender the marriage certificate. And the petitioner is able to say, oh, this is how it happened. We have lived apart for this long, and that is all. And the court will give that decision. Now, when parties have given evidence, whether documentary, oral, the court will consider whether the petitioner has shown that there is a basis for holding that the marriage has broken down irretrievably. If the court finds that the marriage has broken down irretrievably, it will make an order of decree nisi. Please, decree nisi does not dissolve a marriage. I will talk about this when I'm talking about Amobi and Nzegu. And the reason why I'm talking about this one is that some of us, when as practitioners, we don't advise our clients well. We say, oh, the court has dissolved this marriage. Maybe your client already has somebody by the side that is going to marry. Maybe they even come to court together. So you just tell the client, no, the thing has been done. I think you can go further now. That is wrong, because decree nisi is only a provisional order. It does not dissolve the marriage permanently. The parties remain married. It is only when the decree becomes absolute, after a period of 3 months, that you can say the marriage has been dissolved. Now, this happens in cases of administration of estates. Amobi and Nzegu, between the time of decree nisi and absolute, he went to marry another person. Of course, the court found that at the time of and he died subsequently, that at the time of the death, he was still married to that person, that they have been apart for many years.
Hey.
So what is the point? Don't tell your clients to go and marry maybe after a day or two after decree nisi. Wait for a period of 3 months. And by 3 months, operation of law, it will become absolute. Now, some of us as counsel, we also do not obtain a certificate as to decree absolute. There's a certificate and there's a form for it. So what we do is that the moment we have a decree nisi comes in the judgment. And that is why the court will pronounce a decree nisi and say that this decree will become absolute after a period of 90 days or 3 months. So when we just obtain that, we'll go and keep it somewhere. There's still a task for us as practitioners. After the period of 3 months, you must have that decree absolute signed by the registrar of courts. Now, there are formats for it. If you have seen my work on this, you see various precedents on the decree absolute. It will be signed by the ACR litigation. It's dated. It will show the date of the decree nisi, the date of the order, if there are orders for maintenance, ancillary release, whether you have complied or not. And then if there's an appeal, whether it has been determined, all this will be there. And then you have that certificate. And that certificate of decree nisi haven't become absolute. So that is something we must get. So we have to be careful, and we have several situations like that, especially in administration of estates. You find that later they will come, somebody that has been away for a long time will come back and say, I was married, that I'm still married. And they say, we don't know you. And they will now say, did you dissolve this marriage with me? Of course, the dead will not be there to answer those questions. The only thing that can answer is, where's your decree absolute? So this is something that we need to know as the relevance of decree nisi and decree absolute. Another thing we need to know is that between that 3 months, if the petitioner dies, the parties remain married. So what do I mean? How do I mean? If the decree nisi is made and before it became absolute, the party had died, they remain married. And that is also part of the cases that will be seen in some of these. Just pray that the person does not die if you are waiting by the side until after 3 months. Another thing about decree absolute is that there is no right of appeal. I've talked about decree nisi. You can appeal against decree nisi. And that's within the period because it's a final decision. So, but the moment it becomes absolute, there's no longer a right of appeal. And that's section 241, subsection 2B of the 1999 Constitution, where there's no right of appeal. And this is important because marriage deals with status. The moment that status has been determined and say you are no longer married, nothing you can do about it. Of course, parties can decide to remarry. So that is an area that we need to keep in mind. The fact that you obtain a decree absolute does not mean that parties cannot remarry. Even between decree nisi and decree absolute, parties can reconcile. So, and if you see this graph, you see the decree nisi And then you see the waiting period, and then you have the decree absolute. After decree absolute, parties are free to remarry. So that is what we need to do. Before a decree nisi becomes absolute, the decree nisi can be rescinded. For instance, if a decree nisi was obtained behind you by fraud or suppression of evidence, you didn't know, maybe as an undefended petition, you can come to court to set it aside. But please don't wait until it has become absolute. Because the moment it becomes absolute, the court will tell you, we don't have jurisdiction anymore. So parties can reconcile and they decide to remarry. When it has become absolute, they remarry. Now, I've talked about effect of appeal. Decree nisi is provisional. They appeal, they remain married. The moment you file appeal against the decree nisi, the time stops running. That 3 months stops running until it is determined that it starts running again. And you count your periods of so that it becomes absolute thereafter. That's why, for instance, when you have a decree nisi only, you are doing an investigation into the validity of a subsequent marriage. Apart from the fact that it may become absolute by fruition of time, you want to find out, was there an appeal? So as practitioners, we go to the appeal session, find out, was there an appeal against it? If there's an appeal, everybody go back to status quo. You remain until that appeal is determined or withdrawn. Anyone. Now, there are ancillary reliefs. There is a lot of literature, what we have written on this area. Can they be independent or they must be with the petition? Most times when you have your petition, you will seek relief of if there is custody or the maintenance. You can seek for settlement of property. When the court, the best interest of the child is usually the guiding factor under the MCA and the Child Rights Act. So there are various factors that will be taken: the sex, the welfare, education, religion, age. All this, a lot of jurisprudence on that. Then maintenance of both the spouse or the child. A husband can be maintained, so it's not only for the wife. And then the child of the marriage in MCA, there's no reason to say a child will not be maintained because was born when the parties had not married. As long as it's a child of the party, you must maintain that child. Even if you don't maintain the spouse because you are not married, the child must be maintained. So different, but maintenance will stop after 21 years. Unless the court orders, maybe the child is in school, you continue to maintain. There are maintenance during proceedings, and then there are maintenance after the final order. There's pendentility, that's during the course. You can bring an application that the respondent maintain the spouse and the children while the proceedings are pending. And then final order, of course, that will last until final order of the decree nisi. Then the final order of maintenance can be made by the courts. So the point that is made here is that you may not need to wait until the court determines the entire suit. You can, as an interlocutory application, ask for maintenance, and the court will grant. Of course, you must support the facts. Now, there's an area that is coming up now, that's settlement of property. Most counsel are not leveraging on this. You have a client that has so many property, you are not leveraging on it, because settlement of property is a clean break. The parties will, you now say, oh, this will provide for the spouse and then the children, so they can settle property. But when you have the recent case of Agbuolu and Agbuolu, it's not a 50-50 situation. So there's the matrimonial property either during the subsistence of the marriage or these came together to buy and all of that. But the court will consider, is this a matrimonial property that we need to give? What was the contribution? But the major factor is it should be fair, just, and equitable. So there are authorities on this, and then the court can order the transfer of that property. So settlement of property is an ancillary relief we can seek in the petition itself, and it's usually very good. Now, the last part of my discussion, I still have a few minutes, is on enforcement of the decrees. You know, we talked about from commencement to this, the dissolution, from commencement to enforcement. There are various ways of enforcing. If the court makes an order for settlement of property, or the court makes an order for maintenance, or the court makes any order related to the child, there are ways as practitioners that we can enforce them. Garnishing proceedings, I'm sure as practitioners we know this. So you know where the bank, where it holds an account, you can get the order, garnishing order nicer and absolute, and then you attach. If there's a willful disobedience of a court order, for instance, custody, you are asked to give custody. And talking about custody, of course, you know this is a bigger area. You can have joint custody or sole custody. So when you have a sole custody, or the court makes the order, contempt of court, then the writ of 5A against movable property, you can also use that. They are available under the Sheriff and Civil Process Act. And also under if you go through sections 88, 89, 90, 91, and 92 of the MCA, you see all of this. And then commitments, enforcement of maintenance orders. The court can make a warrant of commitment, can send you to prison. That's the judgment debtor. Another area that is not being explored in the country is attachment of earnings. This is a wide area. There are earnings that you can attach. There are earnings that you cannot attach. But if the respondent, judgment credit debtor, works in an establishment, maybe in an office, you can attach the earnings. You obtain an ex parte order. The order is served on the employers. Please deduct this amount every month and pay to the registrar of courts. The registrar of courts will transfer to the judgment creditor. So attachment of earnings is also a very good one. And there's a steady source of the maintenance of the children. You don't have to be going back to the respondent all the time, because after a few period of time, quarrel will start all over again. So most employed debtors with traceable income, it is very useful. But where they are unemployed, of course, you don't know where to attach. So you apply ex parte, the employer will deduct that amount. So I conclude now, and that conclusion is that the statutory marriages that we have discussed, status, it is not just taken for granted. And there are courts that have the jurisdiction, and that's the high court. Of course, you can have the magistrate court or the district courts where has to do with maintenance. We just talked about maintenance. So if you want to enforce it, a court of summary jurisdiction, you can go there. And another conclusion, just a takeaway as we conclude, irretrievable breakdown of marriage is the sole ground. And we have mentioned the 8 facts you can use. You can use more than one. But please, as counsel, be sure of the fact you are using. Sometimes when you see facts of counsel, they mix up so many things. If you ask them, which of them can you prove? You will start saying, I can do it. You can't prove one halfway and say, I want to join halfway to another one. It doesn't work like that. And then we talked about the two-year rule. Again, because marriage, the sanctity of marriage, you don't rush in and rush out. There are narrow exceptions, hardship or depravity. Service is very important to jurisdiction. And we talked about jurisdiction based on, it must be statutory, domicile. One jurisdiction, you can file in any court, but there's the power of transfer under the doctrine of forum convenience. So proper service is very important. It could be substance service, it could be personal or by post. I mentioned from 11 why it's important and the authority. Decree nisi, decree absolute, we have talked about that. What can happen in between? Deaths. If the party dies, they remain married. So the party must outlive the 3 months period. And then we have talked about the enforcement mechanism. So these are areas. I've mentioned some references in some challenging areas of matrimonial causes that I've written upon, apart from my work in this area, which I'm sure that most of us are familiar with. Thank you very much.
Oh, wow.
Madam Nancy, hope I'm within time. It's 4:20.
Excellently well.
Thank you.
Amazing. Amazing. You have done so well. Thank you so much, Professor Tijani. I'm sure you can see all the accolades coming in, how you were able to unpack all of this within the time given. It's just amazing. And we thank you so very much. I think we'll just go straight to the questions at this time because there are a number of them. And let's see how much we can take within the time limited for it. I would start with Harold Ugwani. He's asked a question, what happens if I think this was answered, but Prof, I don't know what you have to say to this. What happens if the petitioner is domiciled outside Nigeria, but the respondent is domiciled in Nigeria?
No, the duty of counsel is to show that the domicile remains Nigeria. There's a matter I'm involved in. The respondent is in Nigeria, the petitioner is abroad. There's an application to take the evidence of the petitioner virtually. So that can also be taken. It's even better in Lagos now. Most of the verifying affidavits, you can do them electronically. So it doesn't stop you from proceeding. It doesn't stop you from, if the respondent is also the one abroad, you can also follow the same process. But be sure that there is proof of the service. Because if you are going to serve by post, you have your Form 11. Ensure that it is returned to you. And when it is in the court file, the court can decide to hear it as undefended. But if the party wants to defend, then you can go on. The matter will be set down for hearing. Okay. I hope I answered that. I hope that is the question.
Thank you very much, Prof. Something similar to that, perhaps like a follow-up, and this is from Adeyinka Akanji. It says, where a Nigerian couple married in Nigeria, but the petitioner is based in the USA, can he dissolve the marriage in the USA, having served the respondent with all processes?
Yes, of course he can. The question is whether he can defend it in the US.
I think the question is more like the parties no longer live in Nigeria, whether they can have their divorce proceedings in the USA.
Yes, they can. There's what we call foreign marriages. Just the same way that if you were married abroad, but you come, because your domicile is Nigeria, you can dissolve in Nigeria. You can dissolve if the court finds that it's a marriage that is known to the law in the US. It can be dissolved. So what it will be treated as a foreign marriage. Just the same way we can treat foreign marriages in Nigeria.
Thank you, sir. Okay, there's a question here with regards to answer under protest. So can you give a case scenario where a respondent will file answer under protest?
If, for instance, I can give that scenario. If, for instance, the respondent says, we are not married under statute, that what we have is a customary marriage, you can file an answer under protest. You know, I said that the court will only have jurisdiction if it is a statutory marriage. Now, so you can file your answer under, because it goes to jurisdiction. And you say that even if the court, because you find that even if the party brings a marriage certificate, you can say we were never married under statute. Of course, you'll be able to show that. The court can decide to hear you and show that if it's a customary marriage, you go back to the customary court, not the high court. So that's a typical example of under protest, your answer under protest. Then there are some times that a co-respondent can answer under protest, in the sense that you join me as a co-respondent that have committed adultery with the respondent, and you can even service that I was never served. And there are several areas that we can think about, but the most times is this jurisdictional, because it's a question of law that you are saying the court should set down under protest.
All right, thank you, sir. This question, you already answered it, so we'll just move on. You can't proceed with divorce proceedings if you don't have the certificate of marriage. You need the CTC. I think you already dealt with that in your presentation. And Dorcas Thani is asking, still on the issue of domicile, what happens in a situation where both parties have permanently relocated to Canada, but the husband files a petition in Canada in order to benefit from the wife's property after the wife filed a petition in Nigeria to avoid the sharing of her property in Nigeria with the husband?
Now, let me give you a background to this. And this is a recurring thing now because you have spouse moving. If the husband, because the domicile of the husband is the more critical one, the domicile of the husband determines the jurisdiction. The scenario you have given is that both of them have moved. Now, if the husband has not changed the domicile, and how will he change the domicile? He has now regarded Canada as his permanent home. Some will say he has obtained a passport. Of course, if that is a fact that you want to show, you go back to that court, that foreign court, and tell the court that the court does not have jurisdiction because our domicile remains Nigeria. That was what it happened in Bojwani and Bojwani. They are Singaporeans. You know, there were different petitions in Bojwani. In one of the petitions in the UK, they were seeking dissolution. They also filed one in Nigeria. Unfortunately, there were conflicting facts. In one of them, he said, oh, Nigeria is my home. They now showed in an affidavit in the UK court that he said Nigeria was a dangerous place, that he has moved away from Nigeria. So the court now found that, well, we won't have, if that means your domicile has changed. You can't have jurisdiction in Nigeria. So the point that is being made is that it's for counsel to find out what is the status of the fact that you moved does not remove your domicile, because you have a domicile of origin in Nigeria. So that should be playing. Before you can say you have changed that domicile by choice, evidence, a lot of evidence.
Okay, thank you.
I hope that gives an insight to what we have just said.
Yes, yes, sir. Can cross petition be filed separately, or can it be on the same heading with the answer? Dr. Oluwatosi is asking.
No, you know, we also, in our normal pleadings in court, we have a defense and counterclaim in the same process. So if you file, just you have your answer. You say answer and the cross petition. Your heading will just show answer and cross petition. It's just that when you come to cross petition, you will list all those facts that I mentioned, your date of birth and everything, because a cross petition is like a counterclaim. Because if the petition is dismissed, your cross petition can still be set down for hearing. So you answer first, and then your cross petition, you give all the facts, because you may be seeking other reliefs. So that is why it's important. It will be in the same place. You don't have to file differently. I'm sure that we can relate to statement of defense and counterclaim. It's the same thing as answer and cross petition.
Yes, yes. Thank you, Prof. I think you've already answered this in your presentation. Someone is asking, can a petitioner file affidavit and documentary evidence without coming in person to give oral evidence before the courts? I think you already answered that's not a possibility.
Yes, I think so. You can't do that. He can call other people as witness. That's what Olaniyan has said now. You can call other people, but you must give evidence. You can't dump affidavit in the courts. I mentioned that some courts now ask you to file a witness statement on oath. That's allowed. But you must still come and adopt your witness statement on oath. You can't say you have filed that. No, that's the way it works.
Thank you, Prof. This doesn't quite relate to what we are dealing with today, so I'll just skip it. And it's a question on bigamy. I will skip that and go to the next question. The next question from the same person, which is, can a decree absolute obtained when there was no service on the respondent be set aside?
I think I've answered that. Under rescission of decree 9 you can set it aside, but don't wait until after 3 months.
Absolutely.
Don't wait. Don't say you just woke up one day that, oh, I just got this notice that they have dissolved my marriage. Don't wait, because the moment it becomes absolute, your right of appeal is gone.
Okay. Okay, this has a bit of a story behind it. A Muslim client that secured a registry marriage certificate with his wife for the purpose of visa application after their Islamic marriage, and then after some years, marry a second wife according to Islamic marriage. And he now wishes to nullify the registry marriage to do justice for both wives and all the children of both wives. Can he file a petition, and on what grounds? Aisha Saludin Awor is asking.
I don't know about that. I don't know about that. But let me say this, is a touchy area. If you marry under Islamic law, you can't marry under statutes. It will be a void marriage. The same way, if you marry under customary law, you can't subsequently marry under statute to another person. So that we clarify that.
Yes.
So parties can decide, oh, we are married under Islamic law, we now want to go statutory, but the same. Then parties, you can't marry under, say, statutes, and they say you want to go and marry others. Because statutory marriage is by its nature monogamous. So those are a bit of complications, but it can be simplified. If you are staying on Islamic marriage, please stay Islamic and marry as many wives, as 4 as you can. If you are staying customary, stay customary. Don't let anybody tell you, especially our sisters, that, oh, the other wife, or you say the other wife is married under customary. Don't worry, I will take the man to registry. My own will override that other marriage. You are wasting time. It's a null marriage. So that is the point that is being made.
Right. Harold Ugwang is asking, how do you settle a property that is not in joint names of the spouses?
Well, settlement of property, let me give you this background. You know, most of us, when we, well, I would say most of us, when we got married, we were not affluent in that sense. Of course, there are a few that are affluent. Most of us are not. You marry someone while you are in school or while you are working, she maintains the home. You have a settled mind to make contribution to build a house or even properties. If you read Kafi and Kafi, she was maintaining the house. The man became prosperous when he married her. So properties, but first you must know that it is a matrimonial property in the sense that it is joint. It's not my own or your own. Parties must have that feeling. And when you come to the house, this is our house. In some cases, the title documents are in both names. Even if it's in the name of one party, but the way it is treated as a matrimonial property. So where we are now is that first, did they regard it as a property that belongs to both of them? Then two, what was the contribution? The contribution may not be in cash. It may be the support you are giving. There was a case where they said, oh, if it's in cash, come and show us your receipt that you used to buy blocks. And the court found that that was ridiculous. A property that you built for almost 20 years ago, where would that receipt be? Was it contemplated that they will come? So the court will look at this. So the position of the law is that it's not as if they will split 50-50. Oh, you take this one or you take this. There could even be partition. So it's for the court to say what is fair from the evidence, and then it will now decide to settle the property. Some cases, you have more than one property belonging to the respondents. In your compulsory conference, you can say, okay, let the petitioner take one of these, and we keep the other ones. And then you bring it to court. So you have settled property. Or we can partition. You take rent from here, I take rent from here. That is the end. So there are different ways you can settle property, but the parties must show that one, because let me give you an example. There are some that are very, they may be wealthy before marriage. You find that they have acquired property on their own. That is prenuptial properties. That prenuptial property is not subject to division. Then there's postnuptial, that is after they are married. So you must draw that distinction. So you find that the respondent will say, I got this property even before I married you. So that may not be a subject of settlement of property. So the point that is being made is that, number one, the authorities, that it need not be 50-50. First, the court consider what is fair and equitable for both parties. And then the court will make an order that will meet the justice of the case. Advantage of settlement of property is that you can, if it is from a property, you can get rent, do whatever you want to do with it. For instance, if the man deserted, I'm just using that now, as a woman can desert, he deserts and leaves the woman in the house and moves to another house. And the woman has been living in that house, taking care of the children there. The woman can ask for settlement of that property because that's where she has been living for years. Where do you want her to go? So it's for counsel to bring this to the attention of the court and say, settle this property for this woman. Where do you want her to go and start paying rent now? So these are things that as counsel, we look at the situation and see how far we can do for our own clients.
Exactly. Thank you so much, Prof. This question here, I will just read it out, but it's showing like it's some fraudulent activity going on when someone says, if the assets are in the name of his mother, how will it be enforced? Does that imply that the asset actually belongs to one of the spouses in the real sense of it, but is in the name of some other person? Or if it genuinely belongs to some other person, then clearly it is not a matrimonial property. I would leave you to throw light on that, Prof.
No, I think, Madam Nancy, you have answered it. You know, the first test is it a matrimonial property? If you have the property in the name of a third party, how does that become a matrimonial property? Except you create a trust somewhere. Yeah, you know, if you create a trust somewhere, maybe, but it's not matrimonial property. It can't be subject of settlement. I don't know whether some of us follow the situation of a footballer who had bought all properties in the name of the wife, of the mother. And when it came to settlement of property, and he said, the properties are not in my name. So prima facie, they belong to that third party. It is not matrimonial property. So that's the first box to tick.
Yes, very well said. Before we continue with further questions, I observe that my Lord Honorable Justice Eberechi Susan Wike is in our midst, and she has put up her hand to probably make a contribution or ask a question. And I will be yielding the floor to her to do just that. My Lord,
You are welcome, my lord.
Susan, if you'd unmute yourself. My Lord, are you able to unmute yourself and take the floor? Okay, until she's able to do that, we would continue with more questions. And the question now is on burden of proof. How difficult is it for petitioners to prove adultery as a fact for the breakdown of the marriage?
Well, the provision of Section 82 is to the reasonable satisfaction of the courts. You know, I mentioned the case of Eraho and Eraho. This was a case that there were nude pictures that was before the courts. And surprisingly, the court said it was not conclusive. So what is the point that is being made?
What kind of evidence would actually ground that petition?
Okay. Number one, you are able to show that the parties, there were opportunities to commit adultery. In the sense that because it's mostly,
if there were nude photos in compromising situations, would that not be enough?
Yes,
or
that is why
evidence of a living being. How about that? A product.
Let me explain this. That's why I said I criticized the Eraho and Eraho. But what the court said is that those nude pictures could have been taken either during intercourse or after, but or before or after. Of course, we have our criticism, but let me give you an example. If both parties are living together and they are not married, cohabitation is a prima facie evidence of adultery. If you are not married to someone, but you are married, you know, one of the parties is married and you are living together, general cohabitation is circumstantial evidence of adultery. So you as a petitioner, you can give that. If somebody gives birth and in the marriage registry gives the name of a party as the father, that is already evidence of adultery. Because if the man had a child outside wedlock with another person, a co-respondent, adultery is inferred. So that is another way that you can go around it. Then, of course, sometimes you find that if I don't know how counsel can do this. If, for instance, there is venereal disease, let me say this, subsequent to maybe having intercourse with somebody that is not married to, and he comes back home, and the petitioner is able to show that after this period, I had this disease because he had, that shows that he had gone out to have intercourse somewhere, and that is already adultery. So the point that is being made, if there is a case of Akinyemi and Akinyemi, what happened was that they saw the man coming out of the house of the co-respondent at about 2 a.m. in the night. And the court said that that was an opportunity. That is a possibility of adultery having happened. Because what will you be doing in the house of someone at 2 a.m. when you are not married to that person? Admissions or confession is also another means. And how can you do this? Maybe in the exchange of correspondence. One of the parties says that, yes, I'm having an affair. This person also is already an admission. So there are different ways that counsel can prove that, but mostly they are circumstantial, because you may not find them in the act of committing that adultery. I don't know whether that helps.
That helps tremendously. Thank you so much, Prof. I don't know if you're able to answer this. What factors most affect how long a petition for dissolution of marriage lasts?
What
factors could affect the duration of a petition for divorce in court? What makes it last so long? What are those factors? Are there things that people can do to avoid having matters last so long, especially when it comes to emotive cases of petition for dissolution of marriage?
No, it's the general administration of justice system. I mentioned a situation where our colleagues now go to Ogun State to file their petition. And the court will have jurisdiction because there's only one court. You find that in Bega here, I'm told that Bega is in Ogun State. If you just cross the bridge, you're already in Ogun State. There's a court there that hears matrimonial matters. And within a short, colleagues go to Ota, Abeokuta, and within a short period, they get their order. But you know that in particular situations like Lagos, you have so many, the cost list. So the normal thing, they don't give preference to matrimonial causes. Even those that say they are family courts, they hear other matters. So that is the general administration of justice delay that we have. But there's a leeway, and that's the hint I've given.
All right, thank you, Prof. Prof, I was wondering, are you able to say anything on separation and not divorce?
Yes, I can say a little.
For parties, yes, who don't want that stigma of being a divorcee to go for separation, and are there things that at the end of the day would make that choice not to be a better choice?
Okay, let me say this. Number one, the petition for dissolution is the same petition for separation. The order that you are seeking for separation is for parties to live apart under the imprimatur of the courts. Otherwise, there's nothing is not different. Let me say this. We said that desertion, when parties live apart continuously for 2 years or for 3 years, it can be a fact to support that the marriage has broken down. So the parties can decide to live apart, but if the court makes an order of separation, they will not be deemed to be living apart for the purpose of dissolution of the marriage. So it's the same form that you use for separation. And during separation, the duty of the husband to provide is still there. He maintains that he must provide during that period. The only difference is that they are no longer cohabiting under the same roof. So you can have that separation. Some go for separation so that let's weigh whether if we are apart, we can ignite that fire again. And when they have done that, then they can come back to court and ask the court to set aside that order of separation, and they come back again. So that's what happens in separation. And the stigma of being divorced will not be there, but they are living under a situation where the court has given you permission to live apart. So that is what separation does.
Okay. This is a question from Didiamaka Ogunfuyi. What is the procedure for effecting a judgment giving custody of the child to a party? Can the judgment creditor just go and pick the child from the other party, or will he need to go through a process?
No, you can't do self-help. You can't do self-help. That has caused a lot of issues. In Odogu and Odogu, we had a lot of problems where children were kidnapped. Well, kidnapped in quotes, abducted while going to school. So the point is that no, you can't do self-help. You go back to court. Now, if you in the slide we mentioned a few of the steps. You can do committal of the person for refusing. He will be sent to prison. You can ask for that order of committal is very effective to have that of custody. Contempt of court is also is part of the committal proceedings that you can do, so that the party can be punished accordingly. So, but don't do self-help. Go back to that court, ask for committal for refusal to obey the order of court for custody. In Odogu, parties were even asking for stay of execution, and the court said, no, when you are in disobedience of court order, why would you be asking for stay of execution of an order of court that you give custody? So that is an effective way to enforce that judgment. I think my Lord is back online.
Okay. My Lord Honorable Justice Eberechi Suzette Nelson Wike, the floor is yours if you would want to make a contribution or ask a question.
My apologies. I had some issues with my internet. I didn't realize I had the opportunity the first time. Let me start first of all by thanking the learned Prof. Eliasu. Thank you so much for all the light you've thrown, into these subjects you've been talking about and answering questions. It's a very illuminating experience for me. Thank you, and I'm sure we're all enjoying this webinar. Okay, so somebody had asked, as Mrs. Obinwa had mentioned, um, about somebody who had a marriage with a man, her husband, under Islamic law, and then for the purposes of obtaining visas, they had to go the marriage under the Marriage Act, and now, I mean, well, after some time, he now took a different wife, and she's wondering how that affects her. So I'd like to mention that while I was still in the university, and this was in my 5th year, I had the opportunity of choosing the family law as one of my courses at that time, and that was in 1995, I think. So lecturer then told us, and of course we read it in the book that was recommended, Google, for family law. And he made us understand, as we read also in the book, that when somebody contracts a traditional marriage with a particular person and they become a husband and wife under the traditional law, if they do go ahead to now have a statutory marriage contracted between the same couple, there happens to be the consequence of conversion of that marriage from a polygamous marriage, which the traditional law is known to be, into a monogamous marriage that the Marriage Act stands for. If it is between the same two couple, but if it is with somebody else, I mean, if you've already married somebody under traditional law and then you go to marry another person under the Marriage Act, that marriage is void ab initio because the person had already, how will I say now, deferred to the traditional marriage and cannot now go and commit, in other words, contract, another marriage with another person under the Marriage Act. The Marriage Act will not recognize that marriage as a monogamous marriage. It will still be a monogamous marriage because that marriage is void. So now, in the instance of the Islamic law, I want to believe that the same should apply. We were not taught the Islamic law at that time, but I want to imagine that it should still apply. If it is the same couple that going from monogamous and a polygamous marriage and contracting a monogamous marriage now converts that other marriage into monogamous marriage. So the man should not be able to take another wife. That is my own impression. We can investigate it, we can Google, I don't know, maybe not Google, check the books, because a lot has changed between 1995 until today. I want to believe that there has to be an answer to that question. But ordinarily, I would just take it that because of the consequences of conversion of marriage, and that's why people do customary marriages before they go to do that under the act or in the court. So that's the whole idea, to make sure that it ceases to be a monogamous marriage and now becomes or transforms into a monogamous marriage, no longer a polygamous marriage. And especially when it is between the same couple, it is now a monogamous marriage. So it doesn't matter, in my own impression, it doesn't matter whatever the reason was why they contracted the um, monogamous marriage, whether it was a visa or anything. The marriage is a marriage, and it's a different kind of marriage, following or sequel to the polygamous marriage. So that is a monogamous marriage, and that man can be sued for bigamy. He really can be, But I don't know what steps the person that is engaged in this situation wants to take. But to my mind, it is a monogamous marriage. And any other person that comes to disturb the marriage, any other means, I mean, that person will be an intruder. I just thought I should mention that. Thank you for the opportunity, Mrs. Obinwa. And thank you again, Professor, for your very beautiful expose. Thank you. God bless you
Thank you,
all.
my lord. Thank you very
Yes,
much.
sir.
Thank you. I appreciate
Yes,
it.
sir.
I just want to mention this, just follow up to what my lord has said. There's the case of Mohammed and Mohammed. The reason why I don't want to go into it, because a lot of divergent views have come up. So that's why I skipped it. The situation that my lord has just mentioned happened in Mohammed and Mohammed. Was a soldier. He had married under the statute when he was a more junior officer. But by the time about some time, he started marrying more wives. Now, the issue that came up, and this usually comes up when there is administration of estates. So the question was that those other marriages, are they valid marriages for purpose of administration of the estates? So a lot of the upper area court had a decision. It went to the Court of Appeal. There was another decision. So, but I don't want to go into it. It continues to generate a lot of discussion. For customary marriages, we shouldn't mix up Islamic marriage with customary marriage. We shouldn't. Islamic marriages, they have their own do I call it, procedure. So for customary marriage, of course, any subsequent marriage other than to that person that you are married to is a nullity. And I think I think we'll leave it at that. It's a subject for another discussion. Thank you, my lord.
Thank you, my lord. Thank you, Prof. Family law conversation can be highly emotive, and hopefully in the near future, we may host another webinar unpacking issues around this area, because it's Nigeria, plural systems, but all matters still go to the Supreme Court. It still moves in that appeal route. So we should be able to talk about these things and really know where we are headed, and have the law be consistent as much as possible so that people really know what they should do and how they should conduct their affairs going forward. Thank you. This kind of engagement makes the webinar enriching. There's a question here. It says, how do we go about issues of maintenance for children in the absence of a marriage? That is, the parties have children together but are not married. Before I let Prof answer this, comparatively, under UK law, this is a situation. And very recently, there's been consultations to come up with some guidance for a situation like this, because it exists. In Nigeria, it may not be seen as the ideal thing. People are expected to marry, raise children, but there are situations where there is no marriage, but there is a child who needs to be taken care of. So, Prof, what do you have to say to this one?
All right, I think that is also correct, Madam Nancy. Section 70 of the MCA, it defines who you will have a party to the marriage or children of the marriage. Now, that children of the marriage, it need not mean that the father and the mother are married. So if you say you are a child of the marriage, you are entitled to maintenance. So what is the point that is being made? You're being entitled to maintenance as a child, as a person, is because you are a child of the marriage. So you are entitled to maintenance. The spouse will not, well, the mother will not be entitled to maintenance, but the child of that union, well, do you call it a union? Of that, well, what do I say? Of that relation, exactly, that relationship is entitled to maintenance. So there are two categories under Section 70, a party to the marriage or a child of the marriage. And it defines a child of, even an adopted child is entitled to maintenance. If you have done a legal adoption, you are entitled because you are already a child in that household. So that is the way. So you can bring, and that is why in Nigeria, you can do an independent application for maintenance, even if the parties are not seeking a divorce. You can do that in the family courts, either sitting in the magistrate courts or sitting in just for maintenance. You can do, but you are not seeking dissolution of the marriage. You are only seeking maintenance.
Okay, thank you so very much. At the beginning of this session, we had said our time was a 2-hour session. And if we would look at our clock at this time, it's saying 2 minutes past 5 o'clock. So we are going to have to round off here. And it's been a very insightful, engaging session. I do not know how Prof was able to unpack all of this within such a limited time. We thank you so very much, Professor Nasiru Tijani, for your excellent presentation And thank you to my Lord for what you have added to the discourse. I mean, today's session isn't just for family law practitioners, it's for lawyers wanting to gain knowledge in this area of the law. It is for magistrates, judges, it's for everyone who wants to know better. And I want to believe that today, this session has provided clarity and sparked reflection and equipped us with practical knowledge that we can apply in the work that we do and give our clients better service. We can also apply it to our personal lives and learn and know what to do if we come up against certain situations. I want to also thank the section chair. I don't know if she's still here with us up until this time. Thank you so very much for your goodwill message. Thank you to our chairperson. The section chair is Mrs. Folashade Ali, SAN, and then the chairperson of the committee, Professor Olomolade. I keep
Omolade Olomola.
Olomola, forgive me. Thank you. Thank you so very much. The hard work is shining here, and we thank you so much for your commitment to all of this. And of course, to everyone who has made out that time to be here today, thank you so much. Your presence, your questions, your remarks, it's all been fantastic, making this session one not to be missed. And also want to use the opportunity to let you know that we have more coming up in our series. We look forward to connecting with you at our next session. And we're planning to delve into succession and estate planning. It's a deeply emotive topic that requires us to think about things we probably do not want to be thinking about: mortality, family relationships, the dynamics, responsibility, legacy. But trust me, it's worth discussing. So please do keep a date with us next time when you see our flyer inviting you for a webinar. Register, click on it, and be sure to join us. Thank you so very much for being here today. Thank you, and God bless.
Bless you. Thank you.
Thank you very much. Bye-bye.
Thank you for the one.
Bye-bye.
Thank you.
Session. Very insightful. I appreciate it.
Thank you. Bye-bye.